Production funding for Behind the Headlines is made possible in part by the WKNO Production Fund, the WKNO Endowment Fund, and by viewers like you. Thank you.
Juvenile Justice and Judge Dan Michael tonight on Behind the Headlines. I'm Eric Barnes, publisher of the Memphis Daily News. Thanks for joining us. I am joined tonight by Judge Dan Michael from the Juvenile Court of Memphis and Shelby County. Thanks for being here.
Absolutely. Thanks for having me.
Absolutely. Along with Bill Dries, senior reporter with the Memphis Daily News. Let's talk about, we'll talk a lot. We'll talk about the court, some of the history, what the court does, some of the complications, and try to peel back all the layers of what goes on in juvenile court and how it's evolved over time and involved in you've been judged since what, 2014?
2014.
And things have happened since then. But let me start with this question, almost a fill-in-the-blank question. From your point of view, the juvenile court, for kids who go there, it is what for them?
Juvenile court is about rehabilitation, period, end of sentence. If you're in trouble with the law as a juvenile, our purpose is to give you direction so that you can rehabilitate your life and become a productive citizen. The law in Tennessee does not use the word punishment when it comes to juvenile court. Now, I know that frustrates a lot of citizens, but what most folks need to understand is we're dealing with children. We're not dealing with adults. Children are not little adults. They function differently, their brains are different, and the law recognized that before the science caught up to it. Now the science justifies what the law says. So the whole purpose of our goal in dealing with juvenile delinquency is to give that child a chance to do better. Judge the act, not the child, and get that child on the right track.
What age kids go through the juvenile
justice system?
Yes.
Well, technically there's no bottom age, but in the law, a child needs to be old enough to develop the intent. Did a child intend to do the act? Arguably, yesterday I was coming back from lunch and there was an 11-year-old being brought in. And I asked the young man, I said, how old are you? He said, I'm 11. He was tiny. And I told the law enforcement officers, I said, we're not going to keep him. They're going to send him home, which they did. I don't know what he did. I wasn't going to ask him what he did. The average age coming in is somewhere between 14 and 17. It varies.
And the top age is what?
Well, it varies. It's 18 or 19 if you commit an act of delinquency before your 18th birthday.
And when you say delinquency, I think you mean that in a legalistic term.
Yes, I do.
I think delinquency is they skip school. Delinquency is something else in your term.
That is correct.
Will you define that for us
yes.
as we talk
about
a
delinquent act is an act that would be a crime if you're an adult.
Okay.
It is a quasi-civil act. It's not a criminal act. So when a child is charged with something as serious as murder, they have committed a delinquent act, not a crime.
Okay.
We're not a criminal court, we're a juvenile court. Now there are laws in place that let us deal with those very serious issues, but a delinquent act can only be committed by a child.
Okay. A couple more, just again, sort of the universe you live in, and then I'll turn it to Bill to dig in some more of this. How many kids are there? How many kids go through the juvenile court on a given day, a given year?
A given year, the averages are somewhere between 4,500 and 6,000. We'll bump up against 6,000 this year just on delinquent charges. Now, we also have jurisdiction over children who are being abused and neglected, and it's exclusive to juvenile court. Okay. And what the public needs to realize is that those children that we see who are abused and neglected, if we don't break that cycle, they wind up on the other side.
They come back on the other side.
They come back on the other side.
For again, kids who are, do you house kids? I don't know that that's on.
We have a detention center in the building that's run by the Sheriff's Department.
Okay. And they might be detained there for days, weeks, years?
Never years. The longest detention might be 200 days before trial. The average length of stay is about 38 days. This morning when I got up, we had 90 children in detention.
That's going to be my next one.
It's an aberration. About this time last year, we had about 50. We don't know why we have 90.
Right.
But Statistically, our numbers vary over the year.
And last one, just again, you are receiving kids from
Memphis Police Department, Shelby County Sheriff's Department, Bartlett, Arlington, Germantown, Collierville, you name it.
All the municipalities, all the police and law enforcement, they come to you.
They have to. Yeah. They don't have a choice.
Okay, Bill.
So, Judge, in June, there was this letter that you signed, that Shelby County Mayor Mark Luttrell signed and Sheriff Bill Oldham signed, to the U.S. Attorney General Jeff Sessions, asking that the Justice Department end its oversight, which began in 2012 of juvenile court. As we record this show, what is the state of that request?
Don't know. We've not heard back from the Justice Department. There have been inquiries made, I do know that, but I don't know what the answer is. The last answer I got from NPR, which said they were told they're working on it. So that's as much as I know. And let me clarify something, Bill. What the letter actually said was, we're asking, he asked for the letter, General Jeff Sessions asked for the letter. We sent the letter and the request was, please review our actions under the MOA. And if you agree with us, then we're asking you to terminate the MOA. If you disagree with us, send it back and we'll do what you're asking us to do.
Right, right. So in the interim, the Shelby County Commission has approved a new coordinator for the agreement. Basically, someone to oversee, make sure everyone's talking to each other, documents are being exchanged.
Yes.
And that is retired State Criminal Appeals Court Judge Paul Summers.
It is.
So at this point, he's getting acclimated.
Yes, in fact, he will be in Memphis at our building next Tuesday and Wednesday to get acclimated. If you'll remember, Bill, Bill Powell was what we call the settlement coordinator in Shelby County. Bill retired, and because we had not heard anything back on the letter, we wanted to stay in compliance. The memorandum of agreement gives either me or the mayor the authority to ask for who the settlement coordinator is. The mayor had chosen Bill Powell, and I reached out to the mayor and I said, I'd like to choose the next one, and I recommend we choose Paul Summers. The mayor was thrilled with that idea, and evidently Paul was too, because we had a meeting with General Summers, we went through the details. He was obviously well studied on the issue, and agreed that if the county commission would go through with the process, he would take the position.
So if General Sessions comes back and says, I agree with the request you have made, that's not the end of the memorandum of agreement. There is in effect a wind down period.
No.
Is there not? Or that's it?
It would be it. That would be it. Paul would be out of a job.
Okay.
Yeah. Can we back up? I want to put this on you because this memorandum we're talking about predates your election.
It does.
As a judge. And so, Bill, can you do a quick background on why the federal government got involved and what they were concerned about and where this memorandum between the Federal Justice Department, Shelby County, and the court came about?
Sure. The Justice Department did an investigation over several years of juvenile court at the request of County Commissioner Henry Brooks. And came back with some findings and said we see issues, there are due process issues in the court, there are a lot of things that we think need fixing. Ordinarily, the next step might be to go into file some kind of lawsuit in federal court. That's not what happened here. Shelby County Government Juvenile Court entered into a settlement agreement that had very specific and many conditions to it for this is how we agree to improve things, this is how we agree to continue to monitor things going forward to fix these problems.
Those problems, you mentioned due process. There was a lot of emphasis on what I think they termed disproportionate minority contact.
Yeah, equal protection. There are three areas under the memorandum of agreement: equal protection, due process, and safety from harm, which is the detention center.
And questions about how kids were being treated in that detention center. I mean, real.
Well, questions about how children were being treated, period. Not just in the detention center. There were no allegations of abuse in the detention center.
But restraint chairs that were questioned. And
that
so
were purchased with money from the Department of Justice.
Okay.
Let me make that clear.
Yeah.
Restraint chairs at one time were an approved system by the Department of Justice. Things change over time, obviously. And when they asked us to get rid of it, we got rid of it right away.
So that am I right in saying that around the time you guys wrote the letter, as you say, the request of General Sessions, the monitor had come out and said that a lot of the points in the agreement had been met. Certain things had been fixed, but certain things had not.
Yes.
Why is there I think critics have said there's this urgency to get rid of the federal monitor. Is there an urgency to get rid of the federal monitor?
No.
Okay.
No.
So in the Paul Summers role, again, back just to get in the weeds on this, is an outcome of that that agreement from the 2012 Memorandum of Understanding. That someone be in there who is accountable to everyone and say, hey, these things are being addressed and these things aren't.
Exactly.
Okay.
That is his role under the MOA.
Without him, let's say everything, he signs off, the Justice Department lets it go. Who oversees the court? I mean, everyone has, who oversees, where are the checks and balances? Voters.
The Court of Appeals, the Supreme Court.
Okay.
Yeah.
And if, again, if a child goes through the juvenile court, let's say they're not somebody who can afford a lawyer on their own. Who represents them?
A lawyer.
But from a public defender's office or a volunteer or someone on your staff?
The first appointment will be a public defender. Under the law in Tennessee, under Rule 13, if you're indigent and you cannot afford an attorney, the court shall maintain a roster of qualified attorneys to appoint to indigent defendants if the public defender is conflicted. So your first appointment is the public defender. Okay. Now, up until this agreement, we did not have the public defender.
Okay, that's what I'm getting at. Yeah,
okay.
Keep going. Keep going. I think because that's a new thing that the public defender's office is back in the juvenile court.
We use panels, just like the federal government does in the federal courts. You apply to be a lawyer on a panel at the federal court. You apply to be on a panel at juvenile court. Okay. You're vetted, you're put on the docket, and you're assigned cases under the law. And a child comes in, mom can't afford a lawyer, then we pick an attorney off the panel. It's all done by computer.
But not a public defender. That's
before the public defender came in.
Okay.
And that was one of the conflicts that DOJ did not like. Now, since the public defender has come in, those number of panel attorneys have dropped because they're handling about 65% of the caseload. They have conflicts. So if they have represented Dan Michael and Bill Dries before, and Bill was represented by private counsel, Dan gets in trouble again, it can conflict them out, which means we now have to have two private attorneys, okay? So they get conflicted out on, co-defendant cases, multiple cases on a regular basis. And they come in and they say, Your Honor, we can't represent Bill, they can't represent me because of the conflict. And we'll reach out to the panel and pick an attorney.
Then I'll go to Bill. Are you comfortable that in this new world, again, which was put in place in 2012 agreement, and you've lived with, you were a magistrate before you were elected,
I was,
correct? So you worked within the juvenile.
I did.
Yeah. Then you're elected. Are you comfortable that the kids who come through have access to adequate counsel?
Oh, absolutely. Okay. Absolutely.
Okay. Bill.
And on the question of disproportionate minority contact, is an African-American child who comes to juvenile court, are they treated harsher? Are they treated more severely than a white child who is there for the same reason?
I can only answer that on a case-by-case basis, okay? The answer that the Justice Department came up with was that African-American children are treated more harshly than Caucasian children who come into the court system. Well, when 98% of the kids that come into the court system are African-American, the percentage of those kids that get harsher judgments is going to be higher. It's a statistical fact. You can't change that. 88% of the children that we receive at juvenile court come from inside the city limits of Memphis, which is a majority African-American city. 67%, I believe. We have very few children coming in from the outlying jurisdictions. Now, by law, if a child burglarizes a home in Germantown, Germantown police can't keep him in Germantown. They have to transport him to juvenile court. And I try to explain this to the public when I'm out there. Here's the difference. The difference is in poverty, the difference is in resources, the difference is in privilege, the difference is in transportation. Let's take two kids. Let's take one from Germantown, two-parent household, does something really stupid. Now let's take a kid from Frazier. The only adult he has in his home is his mom, and he's got 3 siblings. He doesn't know his dad. I see this every day. The case comes before the court. Child's been taken into custody, brought to juvenile court, standing before a judge for a detention hearing.
Having done, in your scenario, and I hate to interrupt because this is very interesting, having done what level of offense? And we're talking about, in your example, we're talking about the kid from aggravated
burglary.
And
they
we're
broke
talking
into
about
a home.
The kid from Germantown and the Afro-American kid
They
from
both
Frazier.
did ag burglaries.
Okay.
It's a felony. They come in there before the judge. You take the kid from Frazier, his mama may or may not be there. He's 15. You think as a judge, I'm going to release that 15-year-old back to the community when there's not an adult to take him? I can't do that. That would be abandoning that child to the street. So he's going to get detained. Now, this is his first offense. Now, mom may show up later that evening and say, I was at work, I couldn't leave, I get fired, which is a common problem with moms who are trying to support 4 kids with no help from dad. Or she may have been in the courtroom and said, he can't come home. Why? He's ruining my other 3 kids. They're younger than he is. He's out on the street. He won't come home at night. He's all kinds of trouble. It happens on a regular basis.
So is that then a failing of the system that there isn't an alternative for?
No, it's a failing of the society that we're dealing with.
But it's landed in your lap to do something something with it.
And that's my frustration.
Are you limited in what you can do as juvenile court judge for that?
Yes, absolutely. One of my frustrations, and one of the reasons that I was willing to sign off on this agreement, when DOJ came in and made their findings in April of 2012, there was a team meeting of all the senior level folks at juvenile court, and Curtis Person asked the question. He said, we've got 2 choices. We either sign this agreement or we go to court. Go home, sleep on it, be back here in the morning, give us your decision.
Curtis Person being your predecessor.
He was my predecessor. He was my judge at that time. We all came back in the office the next morning and he polled us one by one. Everybody agreed to the MOA. We didn't agree what was in it, but we agreed to do the MOA because we felt as a public organization, the best way to resolve these problems was to not fight it out in court and cost the citizens millions of dollars and time. We felt we could resolve the problems working with the Department of Justice and their lawyers. And we think we have. The problem we've got to now, though, is that they created such a firestorm with their findings in a city that is as raw as Memphis is on racial issues, that every time they come to Memphis and they stand before the cameras, they raise the ire of problems over and over and over again. My issue as the judge is, we got problems in Memphis. I'm born and raised here. This is my home. You can't put it all on the juvenile court. We know where the problems come from. If you want to focus on solving the problems, you have to get rid of the diversion that, in my mind, a lot of the naysayers are using as an excuse not to address the hard work.
The diversion being what?
The MOA.
I got you. Diversion.
It's a distraction.
I thought you meant legal diversion from
distraction. It's a distraction.
So a couple things. One, you talk about this, the rawness of these issues in Memphis, but I mean, you look around nationally. In the last couple of years, since Ferguson, since all the police shootings, since Charlottesville, more recently, it's a country that has a lot of raw racial issues that go into the criminal justice system.
It does.
And back to your scenario of the kid from Germantown and the kid from Frazier. I'm fascinated by that. We've had lots of people on before talking about these issues of the first touch with the criminal justice system. So back to your scenario for a second. When that child who you say, look, I've decided I can't send him home. Mom's not here. Mom is saying, we don't send him back. He's a problem. What are your options then?
Keep him till trial.
And what does that mean for his life will be what? He will be in a prison outfit. He will be on bars. I mean, really kind of get into what does that mean for him?
He is in a secured detention facility inside juvenile court. He will be assigned a single room, detention room. He won't share a bunk with anybody. He'll be in a room by himself. He'll be in school every day. School is open. We have a school up there, all right, Hope Academy. He will be fed 3 times a day, and he'll have several snacks a day. He'll be able to make phone calls every day. He can visit his family. He can visit his lawyers. He will wear a uniform, more or less, that we provide that is ascribed to by the federal folks for suicide prevention, right? You can't give them belts, you can't give them shoelaces, things like that.
What about, we have about 5 minutes left.
Okay.
And again, I think this, I find this fascinating because I think understanding, okay, let's assume for a second that care and feeding is taken care of. What about, back to how you opened the show, rehabilitation?
Rehabilitation.
As he's waiting for trial, what, if anything, is being done, can be done to, whether it's mental health, whether it's morals training, whether it's whatever it is that is starting that path of rehabilitation. Is there anything that you all can do, or that you?
We are doing every day. We have groups come in from the community that talk to the young men. We have a psychologist on staff. We have medical care all the way up to a child psychiatrist. So if they're having problems, you need glasses, and you've lost your glasses, we'll get you glasses so you can read. Now, the rehabilitation starts after trial. Because if you're not convicted, you go home. You've been acquitted. But if you are found to have committed the delinquent act, that's when the really hard work starts. And one of the key components of rehabilitation is having a parent or parents to buy into the hard work it's going to take that child and give him the chance he deserves.
Well, go to Bill. Just a few minutes left here.
So at the outset of this, you said that the juvenile court under Judge Person, you all did not agree with the findings that the Justice Department came back with.
We did not.
So do you understand why there is some skepticism there
absolutely.
From the critics about what happens if the DOJ goes away?
Absolutely. And I think there's a big misunderstanding. You have to read it. The language that African American children are treated harsher than Caucasian children comes from what they call the RRI. It is a statistical database that they use to determine treatment of children based on race. The only people that use the RRI is the Department of Justice. Most people who hear about this think the juvenile court got sued. We did not get sued. We went into an agreement with the Department of Justice. These were lawyers who came in. And I've heard this said before, but they made findings. So what? I make findings every day. My findings are reviewed by the Court of Appeals. My findings are reviewed by the Supreme Court. Who reviews the DOJ's findings in a memorandum of agreement? No one.
Do the monitors, though, who are supposed to be independent of everyone, what role do you think they play? Do you think they have been objective?
No, I do not. Just very bluntly, I do not. Michael Lieber will tell you, he's from the University of Florida. I like Michael, he's a good guy, but he's a statistician. He'll tell you he's paid his house off on the money he's made working as an independent monitor for the Department of Justice. Sandra Simpkins, who's a law professor at Rutgers, who teaches clinic up there. It's first time as a monitor. I will tell you that her reports mimic what she's told by the Department of Justice lawyers. Neither are independent.
Well, again, we talked about this before, but I want to go back to it. If the monitors went away, if the memorandum of agreement was gone, again, that accountability for people who say, look, I want to know who is Judge Michael accountable to? Who is that court system accountable to? Is it just the voters? Because a lot of people don't vote, and a lot of people don't, they're not engaged in the process in that way. You have an 8-year term. So if they disagree with you, they've got to wait 6 years to vote you out of office.
They either have to wait 6 years, or they have to come in and file a complaint with the Board of the Judiciary that I'm not doing my job properly. And have the board remove me.
Back to the scenario that I keep coming back to.
Sure.
I think this is fascinating stuff, and
Sure.
we've talked about a lot with other people about criminal justice and how people get in the
Yeah.
system. Take your scenario down from an aggravated burglary
Okay.
to a delinquency from school. What I think of as a layman's term delinquency, or someone who is just out and about.
Okay.
Is your court the appropriate place for a kid from Fraser or a kid from Germantown to go if they have, quote, violated the law by not being in school?
No.
I mean, for those, and yet, do you
No,
get those kids?
We do,
And
because the law is structured that way, but I don't believe it's correct.
Okay.
You have to understand something. This year, if we get somewhere close to 6,000 delinquent referrals, only about 2,000 of those will get before a judge. All those other kids will be pushed out of the system through diversion. It doesn't mean nothing will happen. What it means is the resources we apply to them does not involve a courtroom.
But do police, because you can't say that the police, we only have a couple seconds left, so we'll have to have you back. Are the police bringing you too many kids who have done low-level offenses that really aren't appropriate, that shouldn't be going into the criminal justice system? Not enough time to answer, but...
Not as bad as it used to be. It's much, much better.
Okay, we will have you
Yeah.
back and we'll talk all
Okay.
that through some more.
All
I
right.
really enjoyed
Sounds
it.
good.
Thank you, Bill. Thank you for joining us. Join us again next week. Good night.